Welcome, everybody. On behalf of Local First Arizona, we are pleased to be here with Jennings Strouss to present Arizona Sick Leave Requirements, Getting Ready for July 1st, presented by Otto, Shill, and Lindsay Leavitt.
Thanks, Kendall. This is Lindsay Leavitt here. I'm an attorney at Jennings, Strouss & Salmon here in Phoenix. And we're excited to partner with Local First Arizona to present some information and resources to its members. Jennings Strouss is a proud sustaining member of Local First, and we look forward to giving you this presentation today. We're going to keep it relatively simple and relatively short. I know that's rare to expect from two lawyers here. We'll do the best we can. If you do have follow-up questions or we didn't cover something that applies to your specific business, feel free to give us a call. Our contact information is on the last slide as well as the first slide of this presentation here. So let's get started. This morning I received an email in my inbox and the subject line said, "Help me," all in capital letters, and it had 19 exclamation marks. And I thought, oh, this should be interesting. And it was a local business out of Tempe who the owner of the business just came back from vacation, and she suddenly became aware of Prop 206, its requirements, and that the sick leave requirements go into effect this Saturday. And so we had an emergency phone call today to get her prepped. And it's with that in mind that we're trying to provide resources to you to help get you and your business ready for Prop 206.
Lindsay, I might add that Prop 206 it was passed because it was a voter initiative, not a statute that went through the Arizona legislature. And many people were aware of and have been talking about for a long time minimum wage and its impact on minimum wage. Many more were unaware of the sick leave requirements, and those were really not a topic of discussion. And all it took for this initiative to be passed was someone who could gather enough signatures to put it on the ballot. And then the messaging was about single moms and people who needed an increase in compensation and time to take away to take care of sick children. And of course, everybody liked that idea, and so they voted for the initiative. The burden on the employers of the state became apparent a bit later. And so now everyone's having to deal with the financial consequences and the regulatory consequences. And I bring that up not because this is a political program, but to highlight the extreme importance of your participation with civic organizations like Local First Arizona. It's very important to stay out ahead of issues like this and to have an impact on them while you can have an impact. The ability of the state legislature to change something passed by voter initiative is much less than it is to change a law passed by the legislature itself. And so this highlights the point that gathering where businesses gather to discuss important issues that affect them is important, and we encourage your active participation in the future. Particularly, even this law is likely to have technical corrections and further regulations, and we encourage you to be active in that process because they directly affect your business.
Thanks, Otto. So let's get into exactly what Prop 206 is. Prop 206, the proper name is the Fair Wages and Healthy Families Act, but we'll call it Prop 206 just for ease of reference here moving forward. The first, and what Otto mentioned, in some people's mind, the most important, kind of the headline of Prop 206 was the minimum wage increase that took place and went into effect on January 1st of 2017, earlier this year. And what that means, and then it also provided that every January 1st of the subsequent 4 years, there will be a 50% wage increase as well. So in January 1st of 2018, the minimum wage will go to $10.50 an hour. The following year, 11, and so on and so forth. And then after it reaches $12 an hour, it will be indexed to the cost of living, and it will increase as the cost of living increases. Now, what's important is this, as it says here on the slide, this minimum wage will affect up to 30% of the workforce, and there are violations and penalties for businesses that do not comply. I was very involved in these Americans with Disability Act lawsuits that kind of took place over the last couple of years here in Phoenix, involved defending those lawsuits. And I kind of foresee that opportunistic plaintiffs' lawyers can take these minimum wage laws and these sick leave laws and wreak havoc, just like those ADA lawsuits did over the past couple of years in Phoenix as well. A special note for Flagstaff, introduced a city ordinance as well that will increase minimum wage to $15 by 2021. Importantly, not on the slide, but I wanted to mention real quick, for tipped workers, that means workers that the substantial part of their compensation is paid through tips. Their minimum wage increased as well, and it's up to $3 less than non-tipped employees, which means that their minimum wage is $7 an hour, and they need to be paid at that rate. And so long as the tips that they bring in ultimately equal, they'll be above that $10 minimum wage.
And for those of you who have tipped employees, it's important to understand that the tip credit is available, but you can only claim it if you can document it with appropriate records. So you have to be able to demonstrate with contemporaneous records that your tipped employees are actually receiving the amount you claim as a credit. This isn't just a benefit to the employer. It requires accurate documentation, and the employees have to actually receive the total wages equal to the tips plus the base.
Right, and so to follow up on that, what happens if you have a tipped employee who is paid at $7 an hour but has a slow week and doesn't receive any tips? What you need to do as an employer is each week you need to verify that with tips and with their $7 an hour, that tipped employee is making at least minimum wage. And if they're not, the employer is obligated to make up the difference so that tipped worker is making at least $10 an hour on a weekly basis. And again, that's on a weekly basis, not necessarily on a payroll or biweekly or once a month basis. It's on a weekly basis. All right, let's talk about the paid sick leave rules. Basic requirements go into effect this Saturday, which is July 1st, and it's paid leave. So what a lot of people don't, a lot of business owners that I've spoken with and a lot of clients weren't aware of before is that neither the Fair Labor Standards Act, the FLSA, nor Arizona law requires or has required employers to provide paid sick leave to employees. Oftentimes employers chose to do that of their own volition, but they weren't required to do that by Arizona or federal law. That's changed now. It's not required under federal law, but under Arizona law through Prop 206, it has changed. Now, who is affected by this? Is there some sort of employee number, the magical employee number that is affected? Yes and no. If you have an employee, even if it's one employee, you're affected by Prop 206. And whether you have one employee or 1,000 employees, Prop 206 is something you need to deal with. There are mandatory sick leave requirements under Prop 206. If you have between 1 and 14 employees at your business, then they are guaranteed to receive, or they're allowed to accrue up to 24 hours of paid sick leave throughout that year. If you have 15 or more employees, they're allowed to accrue up to 40 hours. Now, just a kind of a housekeeping note, it's important that you provide written notice of this, of your employees' rights under Prop 206. You have to provide those in a place that they can be seen in the workplace, and they have to be provided in both English and Spanish. And where can you download these forms? You can go on the Industrial Commission's website. You can download those forms and tape them up to the wall in your office there. Or if you can't seem to find them, feel free to email Otto or I, and we can provide them to you. Now, what's important is how is sick leave accrued? And Prop 206 doesn't require you to automatically dump 24 or 40 hours into your employees' sick leave bank and let them use that whenever they want to. An employee has to accrue those hours. They have to earn it. And the way that they earn it is by working. Every 30 hours that an employee works, they get to accrue or bank 1 hour of paid sick leave. So if they want to take off 2 hours of paid sick leave, they'll need to have worked at least 60 hours. Employers can cap the accrual at 40 hours or 24 hours, depending on if you have more or less than 15 employees at your work site. And it's important, and what Otto and I have seen, and we've been getting many calls from our clients asking us to how can they document this new policy, and how is the best way to communicate this policy to their employees. Our recommendation is that each employer in Arizona have a employee handbook, and that handbook will lay out this policy that the employee can be shown, they can acknowledge, they can keep a copy of it, they can initial it by this specific policy as it's laid out in the handbook, which will allow them to and provide notice to them. And so if you don't have an employee handbook, we encourage you to get one. We're more than happy to do it for you. If you do have an employee handbook, it certainly needs to be updated.
Well, and Lindsay, I want to highlight the importance of that because the statute provides several important elections that the employer has to make. An example is that the employer can elect, under the statutory language, to cap an employee's ability to use paid sick leave at either 40 hours or 24 hours. But if the employer doesn't elect to cap that usage, then the cap may not apply because of the statutory language. So again, we'll highlight this several other times throughout the discussion, but it is very important that you update your policies to make sure that your policy reflects what you're willing to do within the bounds of the law. The next slide, again, this is language from the regulations that talks about how the hourly rate of the employee is computed. When you go to pay sick leave, you have to pay at the same hourly rate that the employee is then earning. And you'll see a variety of circumstances. Of course, if they're an hourly employee and they have one hourly rate, then it's pretty easy. If they have multiple hourly rates because they have different assignments, then you have to calculate some sort of weighted average. It's worth reviewing those requirements and making sure that you understand what the employee is currently earning so that you can pay the employee at the appropriate rate.
Now, it's important to know what are the qualifying uses. What circumstances allow your employee to qualify to use their sick leave time? And the statute and the regulations are deliberately broad, and they're so broad that it's difficult to almost rule out some circumstances. But essentially, if there are mental or physical illness, there's an injury or health condition, they're allowed to use sick time. What qualifies as a mental or physical illness? Well, again, that's open to interpretation, but it's intentionally drafted broad, and employees will, so long as they claim a mental or physical illness, you generally have to defer to that. What's also important is that it's not just for them personally, it's also if they're seeking to care for a family member. Who is a family member? Well, under the statute, it's defined as someone's immediate family, including biological, adopted, foster, or stepchildren, but it's also someone or any individual related by blood or whose affinity is a close association with the employee is the equivalent of a family relationship. If you have for example, if one of your employees has a nephew that lives with them that they've essentially raised or that they take and care for, although they may not be necessarily considered an immediate family member, that relationship determines that they probably can take time off or paid sick leave to care for that person.
It's worth highlighting here that the regulations really are very small. There are a set of regulations in the Arizona Administrative Code that dealt with wages and minimum wage before, and those have been expanded very modestly to include sick leave. Rather than going through the regulatory notice, the Industrial Commission went through a regulatory notice and comment process, and that ended earlier this month. But rather than putting the bulk of the information in the regulations, they created a set of frequently asked questions, which is, by their terms, if you read them, you can see them on the Industrial Commission's website, and they frequently reference, in the absence of judicial guidance or legislative guidance, we're going to do this or that. And so you can expect those positions to change, and those frequently asked questions can be changed without notice and comment period because they aren't regulations. So it's important to recognize in a context where you may have plaintiffs' lawyers looking for violations, particularly for large groups of employees, that you need to keep up to date on what the changes, because the frequently asked questions are the Industrial Commission's opinion about how the statute is to be regulated, but may not be the final word. And it's worth noting, if you get on the website for the Arizona Industrial Commission and pick the box for employers, there you will find the frequently asked questions so that you can read them for yourselves, and you can find sample posters that you can use to give notice to your employees, and you ought to put those posters up, assuming they describe your policies, with your other posters that you have in your office.
Perfect. So we really encourage you to use the Industrial Commission as a resource, and if you still have questions and are unable to find the answers that you're looking for, feel free to get in touch with us as well. The next slide and the remainder of the webinar is going to deal with perhaps the 7 main issues that we find our clients and just generally Arizona employers need to be concerned with as they seek to adopt these Prop 206 regulations and laws. The first one is to make sure they have proper payroll records in place.
So if you look at slide 10, you will see the actual records that you have to have, the time cards and the wage rate tables, the records of deductions, the permission for deductions. These are all straight from the statute and the current regulations. And then if you turn over to page 11, you'll see what those records need to include, 11 and 12 actually. You'll see the requirements that the records need to include. What's most important about this information is that these requirements are not new, and they've applied to wages and overtime and minimum wage for a long time. And I can tell you that when we get into a case, for example, of an overtime claim, it's uncomfortable to be having to go to Google Maps to figure out the distance between job sites so that one can back into a calculation about how long we think an employee has worked because the employer didn't have anybody fill out a time card or a timesheet. So very important that you keep these records. In employment cases generally, the plaintiff has a relatively low burden to allege a basic case that a violation has occurred, and then the burden of proof shifts to the employer to prove that they did comply with the law and that they had a valid reason for what they did. And then assuming the employer can do that, then the burden shifts back to the employee to prove that that's just a pretext. Well, in that environment, that essentially amounts to a rebuttable presumption that the employer did something illegal. And if you aren't keeping adequate records of what's going on and what people are being paid and why, then you're at a real disadvantage to rebut that presumption. So, for example, if you have a disciplinary proceeding going on with someone and they're likely to be disciplined or fired for some activity, and that event occurs in close proximity to them exercising a sick leave benefit, for example, it would be fairly easy for an employee to allege that the employer had fired them in retaliation for using that benefit. And the problem is, if you don't have enough records of the disciplinary process, then it's harder to prove that the two aren't linked. So all of that to say that in the current litigation environment, it's really important to keep the appropriate record. It is important to understand over on slide 13 that all employees are affected by this law. There is no small employer exception, and there are no exceptions for employees. You may make a new employee wait 90 days before they can use sick leave, but the sick leave begins to accrue on the very first day they start the job. Again, this is a place to highlight update your policies. Make sure if you want to impose that 90-day wait period that you do so in a written policy, because if you don't, you won't have the wait period. And then we've talked about this in a number of contexts, but independent contractors are not employees and vice versa, and that issue is governed by issues about who has control over a person's work performance, who provides tools, who provides a work location, who dictates the schedule, and you can't just designate someone as a contractor and pay them a different way than you were paying them before.
Yeah, we could do a whole separate webinar, maybe we will, on whether a worker that you employ is an independent contractor or an employee. We won't get into a lot now, but Otto's right. If you have independent contractors that you think, oh, you know, I classified them as them, I pay them as 1099s, but maybe they're actually my employees, we suggest you talk to either us or your counsel to kind of work through those issues as well. That can set up, if an independent contractor is misclassified, that can set up a whole chain reaction of investigations from a variety of governmental entities. Yeah, that's something you don't want to go through.
It hits you under this law. It can get you into problems under the Fair Labor Standards Act with the state and U.S. Departments of Labor, the
Workers' Compensation, IRS,
Internal Revenue Service care.
So it's a nightmare.
Yeah, very important that you not see that as a way out of these requirements.
Right.
Moving over to slide 14, the law requires that you accrue 1 hour for every 30 hours worked, and you have to show that on every pay statement. You either put it on the pay stub or you include a report, but every payroll period you have to report hours accrued, hours used, and the balance left. For salaried employees who are exempt under the Fair Labor Standards Act, you may, that means they're paid at least $455 a week, and they fall into either the professional, administrative, or executive exemptions. Then you may assume they work 40 hours. We have run into the circumstance where there were other exemptions from Fair Labor Standards Act overtime requirements applied, and those we don't believe those get you out of this law. So for the as they refer to them, white collar exemptions, you can presume an employee is working 40 hours per week. This again highlights the issue that you must keep records, and one of the biggest challenges we're seeing with employers is having to keep records for classifications of employees that they never had to track before. And it has implications for what your payroll system can do, has implications for how you collect the data and how you manage it. And then finally, it's important to note that you must charge time used for sick leave to an employee in the smaller of 1 hour increments, so you can't charge anything greater than 1 hour, or the smallest increment that your payroll system uses to calculate payroll issues.
Otto, can you give us an example of that? So if a payroll system only uses 1 hour increments and an employee shows up to work half an hour late saying that they felt sick, how does that work, and how does that get documented?
If the payroll system uses an hour, then you can use an hour. You cannot use any increment greater than hours. So many paid time off policies provide that you have to use it in half-day increments, for example, or 2 hour blocks. You can't do any of that, but you have to use that smallest increment that the payroll system allows. This means you need to be talking to your payroll provider and finding out what they can do and what they can't do, and it's a big coordination issue between your back office to collect the data and getting it into the payroll system, or if you're running your own payroll system, you need to understand what your software will do.
So if you talk to your payroll provider, then is it the smallest increment of time that the payroll provider can do, or that you're willing to do as an employer?
No, it's the smallest that it's capable of doing.
Okay, so if your payroll provider is capable of doing it in tenths, in 6-minute increments, then that's how it has to work.
Yeah, I suspect that tenths is the smallest you would find.
Yeah.
But, so then the next issue with respect to sick leave is that it must be carried over. Any unused leave carries over to the following year. You can still cap usage in the following year to a maximum of 24, or 40. So you can have a circumstance where an employee has, for example, year one they accrue 40 hours, year one they don't use any sick leave, year two they start with 40 hours and they accrue another 40 hours as they're allowed to do, and now they have 80 hours during year two. There is a discrepancy between the statute language and the regulatory language. The statute says that unused sick leave will carry over to the following year. The regulatory language says unused sick leave up to a maximum of 40 hours will carry over. That's important because on the one hand, if it's capped at 40 hours carryover and you're capped at 40 hours usage, then essentially what the carryover allows is an employee to start the year out with some sick leave available, as opposed to having to start the accrual all over again, but they never get more than a total of 80 hours. On the other hand, if the statutory language is correct and the accrual is unlimited, then year two you could end up with 80, year three you could end up with 120, and so on. Now you'll see later on that you are not under an obligation to pay out any accumulated unused sick leave, but you worry a little bit about whether there could be a legislative effort to change that. So an unlimited accrual would be problematic. I think the best view for now is to use the limitation allowed by the regulations in your policies, which you need to adopt or amend, and cap the carryover of unused accrued time at the 40 or 24 limit, so at least you have whatever caps you can have. And then should we see further legal action or legislation or whatever, we can make adjustments. But it's important to note that issue is sitting out there.
Yeah, and then again, referencing my phone call this morning with my frantic client, and she was under the impression that any accrued but unused sick leave, she as the employer would have to write a check and pay the employee at the end of the year for any accrued but unused sick leave. And I told her, no, the way the law is currently drafted at this point, you do not, as an employer, have to pay your employee for sick leave time that they have accrued but have not used.
Now, you may do that, and if you do pay out unused sick leave at the end of the year, then you don't have to carry anything over, obviously.
Yeah.
But it is permissive. It's something you would have to do within your policies, and so it's an affirmative decision you should make.
I'll have to check our own firm's policies and see if I can get a check at the end of the year, because I haven't been sick in a long time, but it's a good idea. Okay. Moving on.
So with respect to the accrual, as we've said a minute ago, you have no obligation to pay out unused sick time. Again, please check your policies, make sure it says so. If you intend not to pay it out, make sure it says so. However, you have to keep track of the balance, because if you have an employee, this is particularly true of agricultural employees, but it could be true of others. If you have an employee who leaves and comes back within 9 months, so think of seasonal employees, then you have to put them back in the same position they were in before they left in terms of sick leave accrual. It's a very common rule in the pension world where somebody leaves and comes back within a 12-month period, and their pension balance is restored to where it was. So not an unusual rule, but the 9-month period is a little odd. And again, policies, can't stress that enough. Moving over to the slide 17, this gives you the information that you can use to verify sick leave. Again, I encourage you to look at the frequently asked questions on the Industrial Commission's website. But suffice it to say that you can only ask for verification from a medical professional if an employee is out for 3 or more consecutive work days. So unfortunately, you will have employees that want to take a long weekend, and they'll take a couple of days plus the weekend, and there's really not much you can do about that. The question has come up as we've done these programs, well, what if I find out on Facebook that my employee was really in Las Vegas goofing off instead of home sick? And I think there are a couple of problems with that. One is it's a dicey conclusion because a picture doesn't tell everything. And secondly, you might end up with a National Labor Relations Board complaint because you might be seen as surveilling your employees and interfering with their concerted protected activity. So I think the reality of this circumstance is that for time off of 2 days or less, there's really not a lot you can do. If they're out for 3 days or more, you can certainly ask for limited documentation. It isn't very extensive. And know that because we have some issues that qualify for sick leave, like domestic violence, you may be getting a note from a social worker as opposed to a doctor, and that's acceptable under the rules.
Yeah, quick question for you, Otto. Does it have to be a note from a doctor, or can it be a physician's assistant or a nurse, or does it have to be someone with a...
No, it can be a number of medical professionals, and they're listed in those frequently asked questions, and it's worth taking a look at those. Let's see about that. Yeah, we'll move on to the next one. And then many of you have paid time off policies. About 20 to 25 years ago, most employers left a separate vacation and sick leave policy and went to a paid time off policy because they didn't really want to know why somebody was off work. They just didn't care. They were going to give them a certain amount of time, and then that was fine. The problem that gives you in this case is that there are certain rules that apply to sick leave that don't necessarily apply to any kind of paid time off. Remember, as Lindsay said in the beginning, you have absolutely no obligation to provide time off to anyone except as required by the Family Medical and Leave Act under federal law, now the Arizona sick leave under Proposition 206, and if it's a reasonable accommodation under the Americans with Disabilities Act, perhaps under that statute. Those are the only three requirements that require you to give anyone any time off. And other than that, if they don't show up for work, you can terminate them. Whether that's smart in a particular circumstance is a different issue. But so in terms of giving time off, you are giving them something that they're not otherwise entitled to. You may be giving it to be more competitive. You may be giving it because it helps refresh your workforce. The point is you're entitled to set the conditions. If you're giving at least 40 or 24 hours, depending on your size, of paid time off per year for a 12-month period, then you've complied with that part of the legal requirement, but you still have all the record-keeping requirement, you still have all the duty to disclose to the employees each paycheck. You may want to pay out some paid time off. You may not want to pay out sick leave. It kind of depends employer by employer, and so this is another point where you need to look at your policies. Often we are recommending that you have two separate policies because then it just makes it clear.
So Otto, can you talk about that a little bit? Because I have, clients, and we have clients who have just a 2-week PTO plan. They don't care if you're sick or in Disneyland. That counts as you're under your 2 weeks of PTO. Now you have 24 or 40 hours of paid sick leave. So what should they do? What do you recommend they do with their PTO? When someone calls in, does the employer have to say, wait, are you sick or are you using your vacation time? Because before it used to be the same thing.
Well, the trouble is the employer can't ask, are you sick, unless they're out for 3 or more days. So I think you start with your current policy and you consider what you're giving. Do you cash out unused PTO or not? Does it roll over or not? What are the conditions and terms under which you provide PTO, and are you willing to provide those with respect to sick leave? If the choice is continue to provide the same benefits with respect to everything, even though you're going to split off 1 week into sick leave and keep 1 week in PTO, then you're really giving nothing different than you did before, and then your question becomes, do any of the rules that apply to sick leave put you in a less advantageous position than you're willing to be in? So again, in general, it's perhaps simplest to divide into two policies, but in some cases you may be then giving the employees less than they would have had before. But remember, for example, if cashing out a benefit is something that you're willing to do under a current PTO policy, you might not be willing to do it if carryover of sick leave was unlimited. If somebody clarifies that in a statute and there isn't a cap on rollover of sick leave and they can come 30 years down the road with a very large bank of sick leave, you might not be willing to cash that out, and you're not required to. So I think we can make some generalizations, but it is dependent on your policy, your workforce, what your employees expect, what you're willing to offer.
Otto, I want to go back to something you said really briefly. You're saying that if someone calls in, you can't ask them whether they're sick? Don't they have to provide notice that they're using sick leave time? But it's not until it's the third day that you have to provide verification, right?
True. So the employees, the law says that if sick leave can be anticipated, the employee should provide advance notice, scheduling the time away in a way that's least harmful to the business or doesn't unduly disrupt the business. If there is a lack of, and if you can't anticipate that you're going to need to be sick, you wake up in the morning, you got a cough and you can't get out of bed, then the employer can provide a procedure for that notice. So for example, you have to call in by 8 o'clock on the day of the shift you're going to miss. But if the employer doesn't provide that written policy, then you can't charge the person with the sick leave.
And again, for our clients, we recommend that the employee have to provide written notice, whether it's an email or a text message or something in writing so that can be documented in the employee's file. And again, this goes back, I know it's like beating a dead horse here. And your employee handbook, your employment policies need to be updated, and this is just another example of why that's important.
Yeah, I think that's the case. Although I would say that I don't remember in the frequently asked questions, but I'm not sure that you can require any specific way for them to give notice. So you can encourage them to do it in writing. I would plan on, if they're going to call in to their supervisor, I would plan on somebody having a way to report that if they call in, because I don't think you can fail to give them the sick leave just because they don't follow some protocol in the notice.
Okay.
And then the final slide is really, for those of you who do federal contracting, these rules, or rules very similar to these, were adopted by the President Obama's administration back last November. And I think this is an important time to highlight that when Congress is not capable of accomplishing legislation on a regular basis for an extended period of time, as certainly has been the case lately, then you find more of these kinds of initiatives. So the first thing that happens is the executive branch moves to their employees and their contractors and adopts policy like the one you see on slide 19. You also see local initiatives popping up. So you see now what we're seeing is sick leave policies. I think Arizona is the 7th state in the nation to adopt it. California did it a couple of years ago. You see gender-neutral bathroom initiatives popping up in local jurisdictions. You see marijuana issues popping up. All of these things are reflective of the difficulty that people are having getting something through Congress, and so it gets pushed to the local level. And again, I suppose that is all the more reason to partner with organizations like Local First Arizona to make sure that you know what's going on in ways that affect your business and that you can have an impact, because together the business community has a far larger impact than any one of us can by ourselves.
Yeah, thanks, Otto. So we promised you a 30-minute webinar. We went for 45, which sounds about exactly what attorneys do. On the 20th slide are our names and contact information if you have any additional questions or need help updating your policies. With that, we thank you for the opportunity, and we look forward to keep providing you information through Local First Arizona.
Thank you again for joining us and listening in. There's a lot of information here, so I highly recommend, if you have any clarification needed, to reach out to either one of our presenters here at Jennings Strouss. If you also need any information or connections to payroll companies and otherwise that can help you get all of these systems set up, please don't hesitate to reach out to us at localfirstaz.com. This is a continuing conversation, and we welcome you to share your ideas with the network as we see how this all unfolds. Thank you so much, and we will see you next time.